blog posts to social media captions and from marketing images to chatbot customer service reps, AI-generated content is everywhere. Businesses are increasingly relying on AI to create text, images, and other creative and informational materials faster and cheaper than ever before. For businesses of all sizes, the prospect of doing more for less is so exciting that many corporate decision makers have forged ahead without fully considering the legal implications. But AI-generated content presents a host of legal risks: copyright uncertainty, potential liability, and even regulatory challenges among them. In this video, I'll break down some of the potential legal pitfalls you need to consider before using AI-generated content in your business, and I'll offer some tips on how to maximize your use of AI while still protecting your corporate and personal legal interests. Let's start with the problem of determining who owns AI-generated content. In traditional content creation, ownership is straightforward. The person who creates the work owns it unless they transfer rights via contract. This is true whether you're a photographer taking a portrait, an artist painting a landscape, a YouTuber filming original videos, a musician recording a new song, or a blogger drafting your own copy. If you're doing this for your employer, there are probably work-for-hire provisions in your employment contract or independent contractor agreement stating that anything you create at the company's requests, on the company's time, and or using company equipment and materials is owned by that company in exchange for the salary, hourly wage, or fee for service that you're being paid. But AI-generated content, as of the recording of this video, that's a legal gray area. In 2023, the Copyright Office denied copyright protection for an image created by an AI system, ruling that there must be a human author. I'm filming this video in early to mid 2025, and as of now, the US Copyright Office does not recognize AI-generated work as eligible for copyright protection unless a human has made significant creative contributions. I do expect this issue to continue to evolve over time, so check in with your lawyer to confirm current status. But as of right now, real time in Kristen's world, it doesn't matter how cool or unique the AI-generated work seems. You don't actually own it, even if you were the one who typed in the prompt, unless you've made a significant independent creative contribution to the final product. In my own legal practice, I'm currently seeing this issue arise most frequently in the advertising and marketing space. If you are using AI to create your business's ad campaigns in-house without any substantial edits made by a human, you may not have legal rights to protect your clever ad campaign from being copied by competitors. This is an even bigger issue if you're an independent creator or your business sells creative output to other businesses. For example, you're an ad agency or a marketing consultant. If you or your team relies on AI to create work for your clients' use, you may be contractually transferring rights to works that you yourself do not even have. I'm drafting AI disclosure and even AI prohibition provisions into many marketing and advertising contracts and carefully phrasing representations and warranties on ownership transfer rights based on whether my client is the content creator or the corporate client, and you should have your own lawyer do the same. But as a good rule of thumb, if you want to ensure copyright protection, make sure that a human person edits, modifies, or adds substantial creative input to AI-generated initial drafts. So, AI content for which no one owns the copyright can be problematic, but the risks don't end there. Consider, could AI be copying someone else's work? AI models are trained on vast amounts of data, including copyrighted books, articles, images, and music. If the AI-generated content that you use is too similar to an existing copyrighted work, you could be on the hook for infringement. It doesn't matter that the AI is a so-called black box, wherein you don't really know how or why it came up with the images or text that it ultimately outputs to you. Nor does it matter that it may not have been your intention to infringe on someone else's intellectual property. your ignorance of the misappropriation might not be a full defense. Some original content creators are taking this risk seriously, although to date, the most public cases have primarily targeted the AI companies themselves for using copyrighted images, books, and other works to train their respective AI models without the underlying author's consent. But you should still be aware. If the AI-generated content you use is unduly similar to someone else's original copyright-protected work, you or your business could face takedown notices, cease and desist letters, or even lawsuits. The risk is highest for AI-generated images, music, and written content, which is exactly the type of work that many companies outsource to independent contractors and consulting firms. You can mitigate some of the risk to your business, for example, by having third-party content providers indemnify your business in the event that their work, whether it's AI-assisted or not, misappropriates or infringes on any other party's intellectual property rights. And if you use internally generated AI images, run them through a reverse image search to check for similarities against existing work, and again, make sure that you've added your own human contributions and edits before publishing. Let's move on from intellectual property matters and talk a little bit about AI and misinformation liability. AI is notorious for generating so-called hallucinations, that is, confidently producing false information. If your business relies on AI for content creation, you could be legally responsible for any false or misleading statements. I've posted videos in the past about the significant risks of using AIs like ChatGPT to try to fully replace your lawyer or other professional advisors, and I've shared some stories about idiot lawyers who charge clients for copy-pasting ChatGPT answers into emails that turned out to be misleading and incomplete. As a reminder, this is arguably malpractice, and you have every right to be livid if your lawyer does this to you, especially if they are billing you as if they wrote it from scratch. But skeezy lawyers are far from the only professionals guilty of relying too heavily on generative AI chatbots at the expense of common sense. Whether you are an accountant, medical professional, financial advisor, engineer, or whatever, you are exposing yourself to the risk of malpractice claims if you rely on inaccurate information provided by AI, particularly when you clearly should have known better. Other industries aren't exempt either. If your AI-generated content includes false information about a person or another company, you could face a defamation lawsuit. And if AI creates misleading claims about your products, you could be charged with false advertising or other violations of FTC regulations. I shouldn't have to say it, but I do. Using AI for idea generation or brainstorming is fine. In fact, I think it's awesome. But you must verify all facts before publishing AI-generated content, especially if you're in industries like law, finance, and healthcare, or other heavily regulated industries, or if you're pushing products that are marketed to children or other vulnerable populations. Finally, let's talk about AI bias and discrimination risks. AI systems can reflect biases that exist in their training data, typically outside of the knowledge of both the programmers and you, the end user, leading to discriminatory content and outcomes. If your business uses AI-generated materials to make business decisions, you could face claims of bias or discrimination. The biggest risk I want to emphasize is AI use in employment decisions. Some AI hiring tools have been found to discriminate against women and minority candidates in the resume screening process. If you are using these tools, and especially if you are using them without human intervention, which is what many employers do when confronted with thousands of resumes, your ignorance of the underlying biases might not protect you from an investigation by the Equal Employment Opportunity Commission, or EEOC, or a discrimination lawsuit from a negatively impacted candidate. But there are other risks too. Consider using AI chatbots in place of real-world customer service representatives. AI-generated content has been known to produce offensive or inappropriate remarks, especially when third parties can impact its output. Do you really want to be known as the company with the racist chatbot? If you use AI for hiring, marketing, or customer interactions, audit outputs regularly to ensure fairness and inclusivity, and discuss with your service provider how the chatbot learns from pre-existing data and from ongoing interactions. Feel free to screenshot these quick tips on how to safely use AI in your business. Generative AI can be a powerful and incredibly cool tool for creating content and making your business more efficient, but it does come with some serious legal risks. From copyright infringement to misinformation liability, businesses must proceed with caution. The key is human oversight. Use AI as a tool, but don't blindly trust it. If you have tips on how to successfully use AI in your business, let me know in the comments. And if you found this video helpful, don't forget to like, subscribe, and share it with fellow business owners.